Are you a business owner feeling constrained by endless regulations, mandates, and oversight? What if a constitutional right older than the LLC could shield your business from government overreach? It can. This isn't an LLC or a corporation, it's a private membership association, and it operates differently. The key is moving your business from the public domain into the private domain, changing the rules of engagement. In the next few minutes, we'll break down the constitutional basis for PMAs, their real-world power, and the critical risks you must understand. So, what gives a PMA its power? It's not a loophole. It's a right protected under the First and 14th Amendments for freedom of association. This is a long-standing right. The Supreme Court has upheld it for decades, famously used by the NAACP to protect its members from government intrusion. Inside a PMA, you're not dealing with the public. Your operations are governed primarily by private contract law between members, not public statutes. You create a private space where members voluntarily agree to interact under a specific set of rules, forming a legal barrier to outside interference. This legal barrier creates an incredible shift in power. For public businesses, the burden is on them to prove compliance. In a PMA, that can be flipped. So, the foundation is solid constitutional law. But how does this translate into freedom for your business? This mechanism allows you to set your own rules. Members can establish their own standards, avoiding one-size-fits-all government frameworks. This sounds great in theory, but what specific industries are actually using this to gain more freedom? You'll see some powerful examples in just a moment. Benefit 1. Simplify operations. You can potentially eliminate tedious annual reports and other corporate registration requirements. Benefit 2. Protect information. In an era of data breaches, a PMA offers enhanced privacy and control over member data. Benefit 3. Financial structuring. Operating privately may reduce exposure to certain public regulatory burdens and their associated costs. Reduced paperwork, more privacy, more freedom. Now, let's see these principles in action. We asked which industries benefit. Let's start with one of the most regulated, healthcare. Holistic and alternative health practitioners use PMAs to operate based on professional judgment, free from restrictive insurance protocols. Educators form PMAs to create private learning groups, letting them build new curricula free from rigid public accreditation requirements. You've seen this model before. Private clubs selling alcohol in dry counties or cigar bars, allowing smoking often operate as PMAs. Remember our opening point about mandates? Properly formed PMAs have been used by businesses to legally operate without enforcing certain public mandates. This degree of freedom is immense. It begs a critical question. What is the catch? Ignoring the risks is not just foolish. It's dangerous. This is the most critical distinction. A PMA is not an LLC. An LLC limits your liability. In many unincorporated PMAs, that shield is gone. Let's be clear. You are trading statutory protection for constitutional protection. You gain freedom from regulation, but take on a higher degree of personal risk. A PMA is also not a shield for crime. Courts will intervene if an association presents a clear and present danger. You cannot harm people and hide. Anyone claiming a PMA makes you immune from all laws, especially taxes, is wrong. The IRS is not stopped by the private versus public distinction. So we've covered the constitutional power, the practical freedoms, and the serious risks. Let's connect these pieces to show the core trade-off. Recall how a PMA can shift the burden of proof onto the government? That legal power is the direct result of shouldering the personal liability we just discussed. Operating in the private domain frees you from many public regulations. But as we warned, it does not make you invisible to foundational laws like taxes. The choice is this. Do you want the government-granted privileges of a public LLC or the constitutionally protected rights of a private association? A private membership association provides a powerful legal framework for businesses to gain autonomy from government overreach. It offers a path to self-governance, privacy, and the freedom to operate based on your own principles and agreements with your members. But it is not a loophole or a magic wand. It demands careful structuring, ethical operation, and a full understanding of the liability you are taking on. For the right entrepreneur, a PMA is a declaration of independence. Do your research, seek expert legal advice, and decide if this path to freedom is right for you.